Okay, gentlemen.
Getting back to the grand jury, we all have to stop thinking that we can make a difference independently.
Agreed.
We all have to stop thinking that the courts are going to bow down to a minimal amount of pressure.
You should never go to court alone. You should always go with someone else, and you should have a court reporter to be able to record all the things that are going on so that it can be released to the public later, or
Yes.
go to the appeals court with.
Take a camera with you.
The court of public opinion is more powerful in many respects than the courts of appeal are.
Well, it's difficult to get a camera in the courtroom.
No, you take the camera, you leave it in your car. When you go into the court, you say you're going into the court. When you come out, you sit it out, and you explain exactly what happened while you were in court, and make that your record. That is your record. It's the best record you can get.
Plus you have the audio from being in the court with the court reporter.
If you're allowed to.
You should be allowed to.
Well, you should be allowed to. I just bought a spy pen, high definition. I know I can get it in the courts. What do you think is going to happen to me if I ever release something that wasn't allowed?
Well, they may find you in contempt of court and jail you for a period of time. If you're found in contempt of court, the first thing to ask is that civil or criminal contempt? Because if it's civil contempt, as soon as you stop the process, the contempt is over, you're supposed to be released. If it's criminal contempt, you can demand a jury trial.
Yes.
Yeah, still, the courts have to allow cameras in the courtroom.
No.
No, they do not.
No.
I mean, no, I mean, they can make their rules to allow, and in Connecticut they're trying to create some openness.
The court of public opinion has to take over. The court of public opinion, and that's one of the things I want to do. And I'm a candidate for Congress in 2012. Okay, and one of the things I want to do is I want to stand outside of post offices and get a petition signed to make sure that all judicial proceedings in the state of Maryland are recorded on videotape. Now that doesn't mean
that's a worthy cause,
because it's your fundamental due process right to have that. That's your best evidence, and if you do that, the judges and the attorneys are going to back down, because you can see then what level of corruption is going on in there. You can see which attorneys are bending the law and how lenient they're getting on some of these major crime cases, and how they're wrongfully prosecuting the minorities and the disadvantaged people of this country.
And I would say I have very little experience in the Maryland courts, but I have had some experience in Montgomery County. And the mere fact of audio recording in the Maryland courts makes it so the quality of judicial behavior is far superior in Maryland than it is in Virginia. Because in Virginia, they know that most of the time there is no
it's Wild West
audio recording, and so they can do, I mean, like Judge Wetzel on the 3rd of April, 1995, compared Washington to Adolf Hitler. Okay? And 2 reporters reported it. Well, fortunately, there was a transcript of that, and I was able to get it to prove that he had compared Washington to Hitler. Well, they are so used to saying whatever they want to because there's not court reporters that sometimes they forget and slip up, and you can catch them.
Well, I mean, when this point brought forth in front of a panel of judges, the panel of judges might say, "Well, he just has an opinion." So what?
You're going back. You're going back to the system. You're in a card game with three friends and a victim.
Yeah.
Well, the one judge is going to commit the crime. The other one's going to cover up for him, and then you go up the higher. The superior judges are. Everybody works for the system. Everybody wants to protect the money tree. Everybody wants to make sure that nothing rocks the boat for them.
except it's the blood money. of
They don't
some
care.
Citizens.
Do they care?
They're parasites,
Do they care? No.
but we care.
You may.
So we want to hold them accountable and create justice.
Well, that's what I was saying earlier. We, the people, are the solution. All right. What has to be done is, you spoke about the judicial panel. In Virginia, some legislator had a great sense of humor. He called it the Judicial Inquiry and Review Commission. And you pronounce that jerk, which certainly defines its purpose as reviewing jerk judges. All right. Now, when I was president of the newspaper down in Virginia Beach, I had an article about the jerk, and I spelled it J-I-R-C, as is proper. Well, my copy editor thought that I had spelled it wrong and changed it to J-E-R-K, and so edited in an error, which was just too funny. But anyway, but the jerk is composed of, I don't know, let's say 7 members. Okay, 3 of them are judges. I think it may be more, but basically 3 of them are judges, 2 or 3 of them are lawyers, and 1 or 2 of them are common citizens. Okay, well, I maintain if there's judicial wrongdoing, who should take it? The jerk cost about $1 million a year to Virginia. And there is, oh gosh, I've got it on one of my statistic things. I gave it to you over there earlier. That the number of disciplinings of a judge is less than your chance of getting the writ of certiorari at the Supreme Court. Okay, so like 0.5%. All right, now, that's why you need the special grand jury, so that you can have citizens evaluate whether or not the judge has performed his duty according to the Code of Judicial Conduct and according to the Virginia law. And if he isn't, then bring an indictment and prosecute him. That it should not be a separate tribunal. The jerk, we're not supposed to have separate tribunals for separate people. How is that equal justice? But we have at least 2 separate tribunals, both for privileged people in our America. One is the privileged class of judge, and the other is the privileged class of lawyers. You have the Bar Disciplinary Committee, that's a separate tribunal, unconstitutional. We have the jerk, a separate tribunal for the judges, unconstitutional. Both of those things are unconstitutional and they should be banned.
Well, and something is only unconstitutional if it's ruled such. We can claim something.
Well, it can be ruled such by the legislature. The people who have, one of the problems that we have is we say separation of powers. Don't let the legislature get into the judicial business. That's not what the Founding Fathers thought. The legislature, the balance of power is for the legislature to control and discipline and regulate the judiciary. So it's not separation of powers, it's balance of powers.
In the old days, the legislatures were the ones that did the judicial practice book rules for the states.
Well, they still do officially, but basically it's now just rubber stamped.
Since the Rules Enabling Act,
Right.
in the 1930s was the first one.
1930s, FDR, same time the bar was created. FDR, court packing plan, the whole thing is an FDR thing of taking control of the judicial branch, which he did through the judiciary, or through the bar system.
Okay.
I'm a legal historian, that's,
All right, so George, what do you want to add to this? How can citizens make this work to reinstill the power of the grand jury? And when we're turned away at the court doors, what can we do to get it back? Where's the DOJ? Where's the FBI to protect our civil rights?
The FBI and the DOJ are packed with lawyers. That's it. You're not going to get anybody in the FBI or Justice Department to do their job.
Well, they
US
have on rare occasion. They had Operation Courtroom. They had Operation Greylord.
Yep.
In New York, they went after.
Greylord was in Chicago.
Yeah, and that is so
And then they've been going after individual judges like that Judge Garson in New York. They put a camera in his chambers, a hidden camera, and there's stuff in his robe with cash from a lawyer.
And in 2008, there was a U.S. attorney named Washington in Shreveport who did the broken gavel prosecutions, and he went after two Louisiana judges, state judges, and prosecuted both of them, and a bail bondsman. And what was happening in that case is that the judges were putting higher bail bonds and getting a kickback from the judge. I mean, from the bail bondsman. Okay, guess what?
Unbelievable.
The same thing.
That's freaking unbelievable. I never heard that one.
Well, the same thing was being
Wow.
done in Newport News. Okay, now let me tell you a great story here. There was a
Yeah.
woman who was Linda Kennedy, and she talks about the litigation vortex. She was a professor at Regent Law School. Okay, outside of being a professor, she was a lawyer. She had one of her clients. She discovered that a judge and a court clerk were taking evidence from the files and throwing it in the trash. She got somebody to actually recover it from the trash bin at the courthouse. She then used that and went to the bar for the court clerk, who was a lawyer, and to the jerk for the judge. Okay, this is destruction of evidence.
Right.
Okay, obstruction of justice.
Right.
Okay, felony actions. Nothing happened to either the judge or the court clerk, and they brought charges against her, and she lost her license. I was with her at the Virginia Supreme Court when it happened.
Wow.
Okay, so that gives you an idea of the Virginia system. Let me tell you another wonderful thing about the Virginia system. There was a woman named Robbie Knize who got raped by a Alexander policeman. He knew that, gosh, if you rape them once, you can be, she immediately reported it to the medical authorities in the city. They didn't do anything because it was a policeman. So he came back and raped her again, and then came back and raped her again, and came back and raped her a fourth time. That way, he can argue consensual. It was not consensual. She reported the rapes each time. Now, she then, the Commonwealth attorney in Alexander says, well, we don't like to put our policemen in jail, so they refuse to prosecute. So she gets a private attorney to bring civil charges. And so in the civil charges case, the city attorney pled sovereign immunity and had the case dismissed on sovereign immunity. Sovereign immunity means in the line of duty. So in Alexandria, it's in the line of duty for policemen to rape female citizens. Isn't that a nice benefit? Anyway, then she appeals it to the Virginia Supreme Court, or the judge sustains that and dismisses the case, Judge Schwartzky of Alexandria, and so she appeals to the Virginia Supreme Court. The Virginia Supreme Court upholds Judge Schwartzky's decision. Hello? You talk about justice in Virginia? Don't hold your breath.
Virginia was one of the founding states.
The founding state.
Well,
The founding state.
so what happened?
The bar's formation in the 1930s has basically taken away the judicial branch as a tool of the people to resolve differences in a civil manner. It's become a sandbox, a private playbox for members of the bar. It's the way they personally enrich themselves on the distress of the citizens.
Well, it's, once you get a license to practice law, once you get a badge as a police officer, once you get a appointment as a judge, you are then automatically, you've elevated yourself to a first-class state of citizenry. Everybody else is second class at that point because you have rights and immunities that nobody else can get. And that's not what our founding fathers
And of course,
wanted.
the judges gave themselves
Judicial immunity and so forth.
immunity with Bradley versus Fisher and so on.
If you read the Declaration of Independence in a legal theory concept, it is at its core theme a repudiation of the concept of sovereign immunity. The sovereign king of England was not immune from obeying the laws of England. That's basically what the Declaration of Independence states.
Yep.
And so it says, boom, you are held accountable. And since there are higher laws, you're not obeying the laws, so we're forming a new government because you're not obeying the laws. Even the sovereign. Well, if the sovereign king doesn't have sovereign immunity, then certainly no judge has sovereign immunity. No policeman has sovereign immunity. No.
Well, how can the judges give themselves sovereign immunity?
They can't.
And then once they've done that, they can give whoever they want immunity.
They do it because we're sitting on the couch watching our boob tubes and not paying attention to what's happening in our courts. The courts are our courts, the citizens' courts. They are not the courts of the bar members only. Bar members are public servants. They are supposed to be serving the interest of the people, not the interests of their pocketbook.
Well, you know,
and that's
the
not
Bar
the reality.
Association is nothing but a corporation, and the corporation's interest is only itself.
It's a
Right.
non-profit corporation.
I would say it's a non-profit.
That's the way it's officially registered. Non-profit does not mean non-revenue.
Now I'm trying to.
It's accounting gimmicks to make it so that.
Her name wasn't Nancy Grace, but Nancy with a G down in Florida. She
Yeah.
was a practicing.
Nancy Gray. She was a librarian who went
Okay,
into
you know
the
about her?
went into she
Was-
went
I know of Nancy Grace, but she was in Atlanta as a
I'm sure it's
prosecutor.
Grace, something close.
Nancy Gray, I believe it is.
Yeah.
And she
Yeah.
went into the
They put her
library.
away for practicing law without a license.
Well, I don't know if
And then she made a challenge on the Bar Association of Florida, saying, are you a governmental agency or are you a private agency? We want to know. And they refused to answer because she was putting the pressure on.
Right.
She got an answer either way from the director of the Bar Association. It would mean a lot, because if they were private, what business do they have helping to form our laws? All right,
Well,
if it's a
one
private-
blessing,
But if they're public, then they have to be accountable as a public servant.
one blessing is that last year, it went into effect on July 1st, 2010, is the Uniform Power of Attorney Act. It's been passed by 5 or 6 states, and that makes it so anyone can serve as an attorney for another citizen.
Right.
And you have a series of forms that you have to fill out and get notarized
Uh-huh.
and file with the circuit court, and then do a notice of appearance, just like a lawyer would do a notice of appearance.
Uh-huh.
But you're not a licensed lawyer, you're an authorized attorney in fact. Not an attorney at law, an attorney in fact. And that is a new provision of the law in Virginia.
Wow. Yeah, I want that information, because we're kind of working on that basis.
Now,
We're kind of using the private attorney general label. Do you know about that?
I've heard of it.
And the courts are refusing us to be able to use that.
The courts are refusing the
Okay, and if you
uniform
say,
power of attorney.
Now, we're signing our papers, private attorney general, and there's nothing you can do about it. We keep putting our papers in private attorney general, because there is a basis of law that a citizen can stand up on behalf of the state. When the state does not take care
Right.
of its own, then the citizen can take it.
And,
forward.
and for whatever it's worth, that's the same concept as in the Lincoln Law of 1863, which is the False Claims Act and
Right.
the False Statements Act, which is due to graft and corruption
Right.
in the government back during the Lincoln administration in 1860s. And so it was passed, and it's also called the Keatam Act or the Whistleblower Act of 1863. And so there, each person, if you knew that corruption was happening in the government, you could bring a case and you would prosecute it to a certain point, and at a certain point the Department of Justice could intervene and take the case over and take it to prosecution. Because when you're dealing with a big corporation, you're a little guy, that was the concept, is that the power of the
So what happened
Department
with
of
that?
Justice. Hold on. What then happened was that you would get 15 to 35% of the final award. Well, that has actually been
It's
good,
under
but-
Title 37.
right. There was actually a Vietnam veteran in the 1970s, I think it was, maybe early 80s, who brought a charge against the against the New York Welfare Bureau, who had been doing fraudulent filings, and his portion of the settlement was $15 million. So let's say that he got 15%.
I think I heard this case, and they're not giving it to him because he was.
I don't know about him not getting it, but that was what he was supposed to get, was $15 million.
Right.
Okay, and some people say, oh, well, that's too much. Gosh, that's terrible. And I say, wait a second. He just saved the taxpayers probably $100 million. I'd be happy to give a taxpayer $15 million if it saved me 85. Hello? You know, we need that sort of thing, and we need that because if there's somebody in the government, a whistleblower gets destroyed if they come public and reveal something.
No,
so there's got to be an incentive, a financial incentive for them to risk their career to be able to correct the corruption
What
of the
about
system.
that whistleblower bill that just got passed last year?
Obama's been gutting the whistleblower protections.
Yeah. What's with Obama? He's supposed to be a constitutional lawyer, and everything he does is anti-constitutional. What blew me away about Obama? He goes down to the Library of Congress and he stands in front of the Constitution of the United States.
You mean the archives?
Yeah, National Archives, right. He stands in front of the Constitution of the United States and says, we need to respect our Constitution, but there must be some way we can prosecute terrorists. And I thought, God, how dare him, to stand in front of the Constitution and try to figure out some way to find some loophole to go after terrorists that the Constitution would normally protect.
The terrorists that we have to fear are the American Bar Association and the judicial branch of government. Yeah. They do more harm to society as a whole than all terrorists combined. They do more harm than you can possibly imagine.
Certainly in an economic standpoint.
Yes.
That if you were to look at the economic consequences of domestic terrorism by terrorists in black robes and terrorists with bar cards, as far as the exploitation of the citizens' wealth, it's far in excess to the cost of the Twin Towers collapse, the cost of repairing the Pentagon, far in excess.
The millions upon millions upon millions of people who have lost their homes right now, and at least 40% of them are due to fraudulent documents put into the system by robo-signers and by court-appointed personnel.
Yeah, but that's not working in the favor of the
international bankers.
By the way, Kelton did a lot of that work.
It's all international bankers.
He's the one who really brought that out and pushed people to take that defense to the courts when their houses are being taken. No signed document, no signed, it's not robo-signing, but it's the original document.
No.
And the judges have been going into the favor of some of these.
Maybe 1% of the judges, maybe 1%. The other 99% are not, because why? Because their pensions are tied directly to mortgage industry, banking industry, and stock exchange. Their pensions, so they're not going to bring down any of the big boys.
If that's going to be a deciding point, then any judge with a pension should be recuse himself, right?
Well, I maintain that every judge, you can actually request the financial records of the judges. And you can. When I was at the newspaper, I was able to contact, I think it was Bob McDonald's office when he was the chairman of the House Courts of Justice Committee, and I got a list of all the judges and so forth like that. Since then, my trying to get it has been very, very difficult. So if you're a legislator, you have a chance of getting some of these things, and what we need to do is to get our legislators to get this information, and then we put it up, you know, like the Virginia, you know, the VPAP project, Virginia Public Access Project. I need to get in touch with them because they've been very, very successful in getting a lot of information about campaign finances. Well, we need to get information about judicial finances and have that on the web so that when you go to court, you know what the judge's economic interests are.
Because if it's linked, then he must be.
There is the potential for conflict of interest
Right.
if his financial interests are potentially going to be affected by the ruling in your case.
Well, I mean, in general, these mortgage foreclosure cases.
You're talking about a specific case. I'm talking in a more broad sense.
In general, and I mean, the story is always the same. The judges are going to have a pension, and it's going to be linked to the
Economic welfare of the major
Well,
corporations.
Wait a second. Let's,
Period before them.
there's two different issues. Judges have their own investments,
Yeah.
and then there's the state pensions that they get
Right.
as judges. So there's actually two parts of that equation that you have to look at. One, their personal investment portfolio, and two, the state's pension program investments.
Okay, George, where do you want to take this? Do you want to talk about something more than
Well,
grand juries?
You know,
Another issue?
well,
How about the trappings of the court?
the trappings.
What needs to be fixed to make the system work?
Well, basically,
Okay, I'm gonna name a few, and then you can, and then you can just tell me if I'm on track or not. Okay. For instance, when an order, you get an order either from the lower courts or the higher courts, denied. Okay, no reason. Do you think that's fairness in the system? Or do you think that every judge should be required to place a finding on how he came to his decision? No matter what, at any stage, whether the appellate court or the Supreme Court.
Federal Rule Civil Procedure 55 and 56 make it explicit that they have to have, it has to be signed in a specific manner.
That's federal rules.
Well, but it applies to all courts.
No, it doesn't.
They,
No, it doesn't.
okay, what I'm saying is there has to be a uniform standard of procedure for all courts to operate a minimal standard of procedure. I talked to a gentleman the other day from the court administrative offices in Washington, D.C., and I had petitioned him in his office to produce to me the judicial oaths of offices of 25 federal appointed judges and the 9 Supreme Court justices of the United States under 5 U.S.C. 2902 through 2907. And he's telling me that no, we can't produce that. We will not produce those because they are tied to other documents in his pension portfolio.
That's bullshit.
Well, I agree.
Come on.
Look.
Come on. That's
So-
false claim. Isn't
and
it a false claim
it's
when
exact-
they say something like
Well,
that?
no, false claim
Yeah.
under the 1863 law is essentially a private company with a contract with the government who makes a false claim for reimbursement or payment from the government. Now, there is the companion law that is the False Statements Act, and that is an employee of the government who makes a false statement. So under the False Statements Act, yes, that would be wrong.
Interesting.
And
I learned that from the constitutional expert of the librarian and law expert of the Librarian of Congress a couple of years ago.
And that's also covered under 5 U.S.C. 2902. And it gives specific...
So all you have to do is ask and they have to give.
No, they don't. I got a letter for, after we had the hearing on the appearance at the Supreme Court on Wednesday. I get home and I find a letter from the Secretary of State of the United States.
Well, they denied you, but
And
the
it
law says all you have to do is ask, and they're supposed to give, right?
Well, this is true, but you know what?
It
You
is
just have
true?
to- you
Are you
have to
sure?
keep- You have to keep ramming it down their throat. You know,
Well, you need to have some meat. I mean, maybe it down the throat's not enough. There's
Well,
gotta be.
as I say, the court of public opinion
Yeah.
is absolutely essential. I gave you some of these flyers. One of the things that I try and do is, as a former journalist, and I guess I'm still a journalist, but as a former publisher, what I try and do is I create seeds of truth flyers. Okay, like here is a situation where I have a picture of a SWAT team breaking into a private citizen's residence based on a false charge against the son of this citizen. Okay, so the prosecutor confiscated the computer where these things were done until after the trial. Well, that's a Brady violation. Okay, it's exculpatory evidence that was prevented from
Exactly.
being in the trial. All right,
No,
so
but that's
we've
punishable. That's a punishable charge
right.
that the judge
But
go to
once
jail
again,
for.
you have judges and lawyers and police and deputies all protecting this prosecutor. We're working on it, but we hadn't got there yet. But it's like a battle. You have to wage one thing and you get a
You've been
stalemate.
working on it how long? How many years? This one?
This one is from January last year.
Yeah.
Okay, so I mean we're making progress, but you know
That's almost 2 years ago.
right, it's almost 2 years ago. But it was in January this year that the court case was, and so we've been working it for about a year. Okay, now,
Where's the court case now? After a year. I mean, it's pretty cut and dry. Here's the photos. Shows his guilt. I mean, how long does it take to discuss this? In a
how do you get a charge against a public prosecutor? Usually the public prosecutor is asking for the charges against other people. That's the problem. There's no accountability for public servants to the citizens. We're trying to reestablish it. It's kind of like there used to be a path through the forest, but nobody walked that path for 40, 50 years. Well, guess what? The path gets overgrown. So what we're having to do is bit by bit hack away the weeds that have grown up on that path. Does that happen all at once? No. You have to hack away one weed, and then hack away another weed, and then hack away another weed. And eventually we're going to get that path reestablished. But it's not an easy process. Now, this is another one of Alexandria. Okay, and we've got a petition on the back for a petition of citizens of Virginia to remove an officer. This is part of the law of Virginia. It's never been really exercised. We're in the process of trying to exercise it. What's interesting is that the Chief Justice of the United States, Warren Burger, back in 1978 said, in January 78, ABA Journal, said, our discipline is barely something more than non-existent. Discipline of lawyers for misconduct is an abysmal state in our country. That's the Chief Justice of the United States saying that in 1978. And guess what, friends? It hasn't improved since
But it's
1978.
gotten a lot worse. Let's be honest about that. Hasn't it gotten worse? And the reason why it has gotten worse is because they know that they can get away with it. And every time they get away with it, it's easier for them to get away with it.
That's right.
well,
I mean, to me, we have to get a Department of Justice to start acting, as well as people to come forward as private attorney generals.
the Department of Justice.
Or as individuals before the grand jury
Jury.
to get indictments against public servants who are violating the law. That's what I've been trying to exercise. I've been able to do it one time this year in February, and what happened was the Hitler judge issued, the Judge Wetzel, who compared Washington to Hitler, wrote a supplemental grand jury instructions that he gave to the grand jurors. I had asked in my letter of January 27th to have a copy of any local jury instructions. I didn't get it. But I was in the grand jury room, and they said, well, Judge Wetzel gave us these instructions. So then when we were out in the main courtroom, just before a recess, I stood up and said, Your Honor, the jurors in the jury room told me that they had instructions. In paragraph 2 in my letter of the 27th of January, I specifically asked for those instructions before this grand jury session. I didn't receive it. May I have a copy now? Well, this, in the main session, there's a court reporter. So I now have that. Okay, so it's on transcript. So then I got it. I read it. There were false statements. False statements in a court is perjury. That's jury tampering. So the judge was involved in perjury and jury tampering. So I filed in federal court against him. It got dismissed, but at least did that. Then I also filed for a motion to the. Would you let me finish this?
Yeah.
Then I also filed to the Virginia Supreme Court, and it sat there for 2 months. And then I went down to Virginia to a Tea Party rally on the 18th of April. And I passed out about 1,000 of these flyers, and the very next day the Chief Justice signed an order to assign a judge from another jurisdiction into Winchester to conduct my case. So that's the court of public opinion, where things like this that have staying power that you don't get from an email, that you hand out and it has pass-along impact, can influence people. And as I say, the very next day the Chief Justice signed that, and I have email indications that she contacted the judge in Roanoke, and she contacted the clerk in Winchester, the federal judge in Roanoke, and the state clerk in Winchester, and then there was something from the Virginia Supreme Court. So they all coordinated this thing, but at least the 1,000 pages, a petition, basically a block away from the Supreme Court, made it so the next day she took action. That's the court of public opinion. We, the people, have to get together and make things happen.
Yeah. Bob Bertrand down in Florida is very good on flyers. He's an amazing activist and did a lot of changes down there. Very much like the flyer method. In fact, he doesn't do enough emails. Doesn't do he stands in the courthouse and passes out the flyers and spends.
Emails are good to alert people, activists, to get to a specific location, but once you get to the location, you got to have something tangible that they can give to and they can pass around.
Okay, George, get back into this conversation.
Sorry about that.
Well, like I said, I'm a firm believer that we need to have the Congress of the United States needs to set forth a set of rules that's a model code for every court. We can no longer stand by and allow these judges in individual courts to make up their own rules. There has to be a model code, a professional.
Well, they came up with a model code.
No.
The Rules Enabling Act, which gave judges the right to make their own rules.
No.
So what went wrong with that?
I'm talking about the model code, the model code of administrative procedures for appellate courts.
Well,
Where when you go in and you file this piece of paper, okay, the clerk has to set up, and there is a code. When you file that first piece of paper, they have to set up a mailing matrix, they have to set up assignment cards, they have to set up distribution sheets, they have to set up assignment sheets, they have to send out consenting ballots, they have to send out dissenting ballots, they have to account for every step of which they use a facility. If the judges in a panel looking at an individual case have a conference call, they have to record it. Okay? If they're going to use a conference room, it has to be recorded. The decisions of the panel have to be recorded in open courtroom.
And other things, like whenever, at all decisions, there should be a finding. On all decisions, there
has to be a
right
finding of fact,
articulation.
the conclusion of law.
Huh?
There has to be a finding of fact and a conclusion of law based up by statutory.
How about based on the facts alleged by the parties.
Well, no,
Well,
no,
Which
based
they
on,
don't do. I mean,
based
that's an
on,
important
based,
point.
no,
You
based-
can bring up all this great law that's right on.
Right
But
there.
all the judges have to say, I don't
Supreme
pick that
Court
law.
say it.
I don't pick that law. I pick this law over here. This is my law. I
No, no.
pick that.
They
And
got-
I disavow the other law. Well, what
These
about the other law?
these are the prevailing, these are the rulings, prior rulings of the Supreme Court of the United States. These are the ones that our Constitution was based on. Marbury versus Madison, Title V, right up there on the very top.
Well, let me share.
Okay, it said the government cannot, you cannot legislate your own laws for the benefit of yourself and insiders. And that's
Well,
exactly,
Madison-
it's exactly
Marlboro
what
versus
laws
Madison said a lot
and
of-
courts are doing today. They're
Yeah.
legislating out the Constitution and legislating in preferential treatment for gangster lawyers and mafia-controlled judges.
Well, some of the paragraphs of the citizens' petition for special grand jury against Arlington County says, paragraph 1, Code of Virginia 19.2, 191, and on, plus the October 2010 edition of the Virginia Supreme Court Handbook for Grand Jurors, section 23, titled Convening, states, quote, any citizen or group of citizens may ask the circuit court of a city or county to convene a special grand jury.
May.
I know, that's May. The next one says, as has been set out in section 3, a special grand jury is composed of from 7 to 11 citizens of a city or county selected by the circuit court and summoned to investigate any condition which tends to promote criminal activity in the community or by any governmental authority, agency, or official. The special grand jury, composed entirely of private citizens, is the one non-political body with the legal authority to make such investigations. Currently, there's an investigation going on in Winchester by a special prosecutor, another Commonwealth attorney. That's inconsistent with the law. She's doing a lousy job, Diana Wheeler. Anyway, George Washington, before he became president, wrote to a future Supreme Court justice, his nephew, Bushrod Washington, on the 10th of November, 1787. He said, the power under the Constitution will always be in the people. It is entrusted for certain defined purposes and for a certain limited period to representatives of their own choosing. And whenever it is executed contrary to their interest or not agreeable to their wishes, their servants can and undoubtedly will be recalled. Notice he said servants, not officials, not masters. Now, First Amendment, the right of the people to petition the government for redress of grievances. If you petition the executive, the legislative, and the judicial, and you're not heard, you can petition the grand jury. The special grand jury, composed entirely of private citizens, not public servants, is the one non-political body with the legal authority to make such investigations. Then we go on, and it says there is one of the appeals court judges in Virginia, D. Arthur Kelsey, in the Virginia Lawyer magazine, October 2004, said, to many of the framers' generation, the jury was the lower judicial bench in a bicameral judiciary and the democratic branch of judiciary power. The jury are the best investigators of truth and the surest guardians of public justice. That's Blackstone. Now, former Chief Justice William Rehnquist said in quoted by the Center of Court Excellence and District of Columbia, justice is too important a matter to be left to the judges or even the lawyers. The American people must discuss, think about, and contribute to the future planning of their courts. Okay? And what did this Chief Justice say about the lack of discipline of the lawyers? There is a common thread, but we do not have journalists. I had a page, Constitution of the Courts. That was so rare. There's virtually no legitimate justice, journalism for justice being done in America. And that's why I call myself a journalist for justice. Anyway, but that's...
Well, I don't think that's entirely true, but we appreciate the work you're doing. I mean, that's what one reason why I'm here today is because there's a screaming from every state a yearning that that people can reclaim their judicial system, and it is rampant. It's an epidemic. It's a judicial epidemic. We just simply have to look at the news and see what's going on state by state, and just seeing the trail of corruption. And it's always the same reasons why the judges are corrupt.
And by the way, there's a court case called Wortham versus Commonwealth, which says a volunteer informer ought to be made prosecutor. All right, that's important because that established the private attorney general, the private prosecutor, because, like in this case where you have a Commonwealth attorney and you bring charges against him, are you going to trust another public lawyer to go after a public lawyer?
No.
Okay, no. You've got to have somebody, and in the case that I've got against Arlington right now, my first motion or request for injunctive relief of the federal judge was for a lawyer who is not a member of the Virginia bar and that was allowed to practice in the federal court in Virginia on a basis of called pro hoc vice, which is essentially a visiting lawyer being allowed. Okay, the reason for that...
That's the exception.
Right, the reason for that is I wanted them to be free from fear or favor of losing their bar license by going after members of the bar who are not doing their duty. Okay? If you have a Virginia lawyer and he goes after a Virginia judge or a Virginia lawyer,
well,
6 months later he might lose his license.
Yeah, but you have somebody from out of state making the prosecution.
It's a little bit more insulation.
Very little. Because they'll cross borders and come back and get you.
Granted, but the reality is the case of Linda Kennedy, who lost her license when she reported a judge and a court clerk bar member for felony removal of documents.
Yeah, that's just unbelievable.
Obviously I need to request that, and I did. Now, whether or not it gets granted is frankly not likely. But if you don't ask for it, you're certainly not going to get it.
Okay. What is the role of media play in judicial reform?
There is all media in this country is owned basically by five corporate giants, and the media will never. The media in this country is mostly a disinformation.
Major media.
Major media is disinformation gathering. All we can hope for is the internet and activist groups to come back and try to take over and rebuild a media system that can get out here, because all the major media,
Blogger News,
mainstream media does cover these stories.
No.
Yeah,
the only time
yes, they do.
On
For
very
instance,
rare
Judge Garson stuffing his robe with cash. They sure played that a lot. But the thing is to
how much you heard all this.
The newspapers are worried about when they have their day in court what the judges are going to do to them if they report unfavorably before.
They're worried about the advertising dollar.
Well,
if the American Bar Association withdrew the advertising dollar from the local media, they would all collapse overnight. That's where the money's at. The advertising.
The lawyers need to advertise.
Well, the lawyers and the corporations that they interest. You got to realize 735 corporations control 98% of the wealth in this nation. 735 corporations, 98% of the wealth. Okay.
Okay. I'm gonna pause for just a little bit. I think. All right. So George, in conclusion, what would you like to tell the American people how we can go about restoring faith in the courts?
Well, first and foremost, the only way you're going to restore faith in the courts is to expose and have full transparency within our judicial system, our judicial branch of government, to make our all parties within the court system from the local sheriff to the Supreme Court justices, all make them accountable to the oaths of offices that they have signed in their employment contract with their respective.
So when we try to do that, it gets stifled, so how can we?
No, why does it get stifled? It's a mandatory contract. 5 USC 2902. It's a mandatory. They sign a document that says, yes, I will uphold and defend the Constitution of these United States against all enemies, foreign and domestic. I will adjudicate and I will distribute justice in an equitable, fair manner. Now, that's not a gray area. There's nothing gray. It's black and white. Now, if you allow the ruling class to take and disregard their own oath of office, and you expect the subservient class to be held accountable for any for violating laws that they are not even aware of. In many cases, they're being put in jail for laws that they're not even aware of. What kind of society do you have?
Right, but we're looking for a solution here. And James?
Well, I believe, as I said before, that the problem is we the people, the solution is we the people. We the people have to get involved in the administration of our courts. Not their courts, our courts. That is, when a public servant in the court, in the judicial branch, in the executive branch, in the police, do not obey the laws, then we need to go to a grand jury, get indictments, and do private prosecutions and put these people in jail.
Okay, now George, talking about the federal legislature, what kind of legislation can we write up?
I believe in ground up, or
Yeah.
bottom up.
Well,
Bottom up solutions rather than Congress
Well,
down.
you've been doing bottom up, and you've come to a dead end with the state court.
No. I have been doing this since January.
Right.
Okay, one person, I've gotten 2 other people to help me in doing it, and a couple other people who are sort of, co-plaintiffs with me in Arlington. All right. A war, it took George Washington 8 years to win the Revolutionary War, and he had a whole lot more resources. Okay, we are making progress. It's not something that you snap your fingers and the solution is there.
George talked about the working in Congress and trying to get unified
well,
law.
you've got to
trying to create a better mechanism.
Well,
so when a judge
we
breaks
have
the law,
we have a system of laws that the Congress passed. The Congress has got to make sure that those
well, they're not
laws.
working. So what more do we need?
Well,
to
what are you
do?
talking about? That's the problem. We need to hold all of our elected, appointed, and hired government officials.
So what's the mechanism? We know this, and people have been trying, but the courts are so corrupt, we get knocked down. So what's going to make it stick? I think that if you had 100,000 people standing around a courtroom, like Louis Farrakhan can do, you'll see an effect.
Well,
when people actually take the courts back physically, that's when I think we're going to see some change.
that's not going to happen.
Well,
I think it's beginning to happen already, not just for the courts, but for all 3 branches of government. There's a new cry for accountability.
Well,
Like
that is positive.
And since the '60s, but and never this strong in this way.
A positive assertion of citizens' rights
6 minutes.
is fine. A taking over of the university president's office, like during the '60s, or the taking over of a court, is improper. We have an excellent Constitution if we would exercise it. Part of the constitutional rights is the grand jury, and we are not executing it. We're not exercising it.
We are, but the judges aren't
No,
letting
we
us
are
get
not.
there. You tried.
Wait a
You
second.
tried.
Have you tried it?
Yeah, we're trying it now.
Okay, but
I-
the point is we're talking a handful of people. When you start all of a sudden having hundreds or thousands of people across the country in jurisdictions everywhere, then it's not I, the individual, as the start of the Constitution. It says we, the people.
Right.
That means more than
That's
just
what
the
we
people
do.
in this
We
room.
do-
That
we
means
do
thousands of people in separate individual actions collectively
Right.
exerting our rights. It's not individual exertions, it's collective we the people exertions. That will change the system back to, that will clear the pathway back to a republic that we once had.
Okay, that's a great ending statement. Anything else for you, George?
It takes numbers. If the victims of these judges would just come forward, if they would join together in unity, one with another, tell their stories. You know, I do victim stories on my website all the time. You can't sit back in a corner and cry. You have to let the people know what really happened to you and why you lost your home or why you were put in prison illegally and what happened to you in prison and the steps that you took to try to rectify that. If you don't join in unity one with another, then the courts win. The judges are going to keep being corrupt. The FBI and the justice. The FBI, you talk about that. The FBI is only funded enough to prosecute 300 cases a year, according to a 1997 statement by the head of the White Collar Crimes Division. At that time, we were losing 700 times more financial losses in white collar crimes every year. Today it's probably 7,000 times, and they're still cutting the budget for the Justice Department and the FBI so that they can't go after these white collar criminals.
All right, that's the FBI subject, but make a conclusion here for the whole thing.
The whole thing is unless people become proactive, unless they support groups that are growing up trying to make positive change for the future so that your children won't grow up in debt slavery or be wrongfully imprisoned or sent off to detention camps, you need to open up and find out what's happening not only here in the United States. This is going on in, right now, Australia is going through the exact same thing.
So the time is now.
The time is absolutely now to raise up and to defend the Constitution and Bill of Rights.
All right, thank you.
Okay.
That was pretty good, I think. What do you think?